Good morning from the Benelux Office for Intellectual Property, and good afternoon to you. It is an honor and a pleasure to be able to participate today, albeit virtually, I'm afraid to say so. Actually, I'm going to give you a presentation about the current system, and later on the colleagues from the European Commission will present, I would say, the most interesting part, the future of European design law. I'll try to be as brief as possible. I'm really looking forward to it. I'm also looking forward to learning more about the Taiwanese system. So if we could go to the next slide, please. I prepared a very short program. Also, given the time, it is of course not possible to explain to you everything about the design system, which exists for years and years. And so I stick to some main issues. The first one is a bit the legal system that is currently available in the EU. The second issue is what can be protected as a design and what cannot be protected as a design. And the third issue is, well, I think the question d'existence. It is like, why do you need to protect your design? If we could go to the next slide, please. Well, I think the first thing to realize when we're talking about the EU design landscape is that there's no such thing as one single legal system. There's actually, within the European Union, there are two systems that are living together, I would say. There is the community design system, which is governed by the Community Designs Regulation. And there are national, or in our case, supranational Benelux design laws. It is important to stress that the design law, also the national systems, are to a large extent already harmonized by the current European Directive on Harmonization of Designs. And there are, as was already said by the previous speakers, there are plans to further harmonize design law. And there's a third option, which is the international design, to the Hague system, where you can either choose for either community design or national design protection. Next slide, please. First, the community design, the registered community design. Registered community design is a very strong weapon in the fight of counterfeit. There are quite a lot of design applications. There was like almost 100,000 designs yearly. They are valid throughout the EU, so in all 27 EU countries. They must be filed at the EU IPO, which is located in Alicante in Spain. They're valid for 5 years, or I must say 25 maximum, but they can be renewed every 5 years. And they give very large protection both against deliberate copying, but also against independent development. So if you go to the next slide, please. The second legal means of design protection in the EU is, I guess, even more convenient because you don't have to do anything to obtain it. It is the unregistered community design. It exists, or it commences from the first divulgation of a design. So the number is infinite, I would say. Every minute, every second, there are new unregistered community designs created. They also give a very good protection, but shorter than the registered version, namely 3 years after the first divulgation, disclosure. And they only protect against deliberate copy. So you have to prove that the other party knew about the previous design and he deliberately copied it. Next slide, please. Then you have the national systems, or in our case, what I just said, the Benelux system, Actually, the protection that is offered by those systems is comparable to the registered community designs. It's also maximum of 25 years. It's also against deliberate copy and independent development. It must be filed at our office at BOIP, the Benelux Office for Intellectual Property. And the numbers are quite limited, or I would say the success of the community design is clearly visible on the picture. You see that we have a little bit less than 1,000 designs. I will later on explain, I think, also the legal reasons why national designs are not very popular anymore. Next slide, please. And then as a last thing, you have the international design, which is governed by the Hague Agreements. It's one of the WIPO administered treaties. It is quite convenient because you can obtain design protection by a single application at WIPO. You don't need a basic application like you need for the Madrid system for the trademarks. And you can choose the contracting parties of your desired protection. So it can either be national or also the European Union in one single application. I must say the numbers are also quite limited. I was a bit surprised actually. They have like 6,000 applications a year. So I guess that most design owners, they file directly at the office of their interest. Next slide, please. Well, the second issue that I would like to discuss today is what is a design, what can be protected and what cannot be protected. Next slide, please. And there we go to the legal definition of a design. A design is the appearance of a product or a part of it. It is like the visual appearance, so everything which is not visible from the outside cannot be protected as a design. And a product must be an industrial or handicraft item. I think this is an important element because this excludes items that are not used that don't serve a practical purpose, I would say. If you would have a painting or something, it can be very nice, but cannot be protected by design protection. It must be industrial or handicraft. Two very important elements for the product to be protectable as a design. They must be new and they must have an individual character. Next slide, please. Well, to give you some examples about what can be protected, I put some nice design things on the sheet. These are all products that serve a purpose. You can ride a bike, you can move your children from to school in it or whatever. We do that in the Netherlands quite often. Or you can make a nice cup of coffee, or you can use it as a telephone or a bag. These are all things that can be protected as a design, that fall under the definition of a design. And for the next slide, please. I think it's also important to realize that there's often an overlap, that a single product can be protected by several IP rights. And further on in the program, there will be also a lecture about overlap between copyright and design rights, so I won't say anything about it now. But as you can see from the picture, like if you have a car or a bike or whatever, it can, of course, the emblem and the name of the car can be protected as a trademark. The visual appearance of the car can be protected as a design. And of course, there can be patents for engine or brake systems. Next slide, please. What cannot be a design? What is excluded as a design? Well, in the first place, it follows from the very definition of a design that it must be novel and have an individual character. individual character is that the overall impression differs from the impression given by the design acquis, I would say, the already existing designs. And what is relevant for the design acquis, it is the every design that was disclosed in any way, so that it could have been come under the attention of the interested circles in the EU. And actually, that is quite a large definition. It doesn't only mean that if a design has been made available to the public within the EU, it is not new anymore, but also if it was made available to the public outside of the EU, but there could be experts from the EU who have viewed it. For instance, if a new car would be displayed in the Detroit yearly car event that they organized there, then it is already not new. So actually, and this is an important feature which counts both for community designs and also for national designs. So a design which was published or made available to the public outside of the territory concerned also harms novelty. And I think this explains to a great extent why the popularity of the EU design compared to the national designs. Next slide, please. Other things that are excluded as a design are things that are exclusively dictated by the technical function. So as I already said, technical things can be protected by patents and visual things by copyright. And you have, of course, the flags that are protected under Article 6 of the Paris Convention, and designs that are contrary to public policy or morality. Actually, I didn't put an example of that on the slide, but I think you can imagine what I mean. I think it is important to stress that in most European countries, at least in both the EU design, the community design system, and the Benelux design system, there's no substantive examination done by the office. So both BOIP and EURPO do not examine whether or not a design is novel or has a distinctive character. The only thing that is examined is the limited grounds on this slide, namely the public policy or morality and the 6 designs, but actually they hardly ever occur, I would say. Now, next slide, please. Then we go to the final part of the program. I see I'm a little bit behind of time, but we started a bit late. Actually, next slide. Well, the last thing I would like to share with you is why to protect the design. Next slide, please. I think the answer is quite obvious. You protect the design to be able to fight counterfeit. That's the most important reason, actually. And put on this slide, well, I would say the legal disposition about what is protected and what can be done. It is a design is protected against any other design that doesn't have another overall impression to the informed user. I'm afraid I have to put on my glasses. The registered design gives an exclusive right, and you can prohibit not only the making, but also the offering, importing, putting on the market, etc. of the products. And there can be all kind of enforcement measures taken by the design owner. So it gives, especially the registered designs, they give quite a strong weapon against copying. Well, then we can go to the last slide. Next slide, please. Which is actually a bit of a personal thought that I would like to share with you as a last thing in this presentation. I think it might look a bit odd, or it might sound a bit odd from what I would say, a humble public servant working for an IP office. Actually, in my view, protection should be the exception and not the rule. And I think if everything could be protected and everything was to be protected, I would say after the invention of the wheel, the world would have literally stood still. So I think it's a good thing that not everything is from itself or from the creation protected, and that the legal definitions that are used for instance, design protections, they clearly relate to the appearance of a product and not too much beyond it, and that they are limited in time. So I think the 25 years is enough to profit from your invention or from your design or whatever. Next slide, please. Thank you very much for your attention, and I'm looking forward to the rest of the program.